Welcome back to Legal Link. Your host, Scott Newmark. I've got a very special guest with me this evening, Nina Zuckerman Chepp at Wintter and Associates. She's an attorney, and we're happy to have her here. Nina, welcome.
Thank you, Scott, and thank you so much for asking me to be on the show with you today.
Our pleasure, our pleasure. Nina, let's start off, and what I'd like you to do for our audience is give them an overview about your practice.
Okay, Scott. I am a partner at Wintter and Associates. We are a 4-attorney boutique law firm with our primary office in Hollywood, Florida. We handle exclusively matters in probate, guardianship, and trust administration, estate planning, and probate, guardianship, and trust litigation. I myself have been practicing in this area for more than 26 years. I actually kind of fell into it a little. I didn't know what I wanted to do when I graduated law school, and had been involved somewhat because my father passed away suddenly, was personal representative of his estate, so ended up having an affinity for this practice area. I handle the probate, guardianship, and trust administration and estate planning in the office. So over my 26 plus years, I've probably drafted hundreds of wills and administered thousands of estates and handled and helped many families through the guardianship process. However, when there is a dispute, my partner, who happens to be board certified in the area of wills, trusts, and estates, and his team handle the probate, guardianship, and trust litigation matters.
All right, let's take a step back because you used a lot of terms. Tell the audience what probate is.
Probate is the process of when somebody dies and they have assets in their name alone, as opposed to maybe a jointly held account or an account that has a beneficiary designation, how those assets then go from the decedent to the beneficiaries. A lot of people think it's a very complicated and scary process. Court intervention is necessary in order to get the assets out of the decedent's name and for a beneficiary to ultimately receive those assets. However, when you hire the right attorney, such as my firm, who handles these matters exclusively, we try to make it as painless as possible. Most probate matters do require an attorney to represent somebody in order to obtain the assets. So when they come to my firm to retain us, we meet with them, we review the steps involved, and primarily try to hold their hands and take over most of the responsibilities so that we just simply guide them through the process to make it easier for them. Probate can happen when somebody dies with a will, which is called testate, and we represent the nominated personal representative who, as long as they're qualified to serve as personal representative under Florida law, will be appointed to make sure the decedent's wishes are carried out and his assets distributed to those people that he wanted to receive them. If you die without a will, there tends to be a misconception that your property will escheat to the state. That does not happen. Under Florida law, it is determined who will be the personal representative of the estate. And as far as the beneficiaries, Florida law designates that as well. And it's typically spouse, children, parents, siblings. There's a statute that will designate who would receive the assets of the decedent.
Well, let's talk about probate a little further. Is this something that should be avoided or actively gone into?
Well, a lot of people come to me especially when I meet with them to do estate planning, and say, I want to avoid probate. Certainly as a probate attorney, I don't want people to avoid probate, and I don't think that it's really a bad thing. It does take some time, But again, with our guidance through it, it's not difficult. There are ways to avoid it. As I said, if somebody dies and all their assets are jointly held or have a beneficiary designation, then there's no need to probate an estate, even if the decedent had a will. If the will says the assets would go to somebody else, but all of their accounts have a beneficiary designation to a different person, those accounts are going to go to that designated beneficiary. There are other mechanisms to avoid probate. However, that's really on a case, an individual case basis to see if somebody really is necessary for somebody to do a trust or other methods to avoid probate.
Well, share with us, Nina, if you could, what types of disputes can occur in probate?
Well, as I said, my partner handles those matters. And primarily when their family doesn't think that the testator, the testatrix, which is the person who is writing the will, either the male or the female designation, has done so of their own volition, whether there's been some exploitation perhaps. Here in South Florida, unfortunately, there's a lot of elder exploitation, and it happens not only with caregivers or strangers, but sadly within a person's family, where maybe there's one child living in South Florida and another who lives in New York or out of the state, and that child has exerted influence over mom or dad to make them change the designations on their accounts or how they want their assets to be distributed under their will.
Nina, are there alternatives to this probate process that our audience might want to know about?
Well, one alternative is drafting a trust. As I indicated, that's really done in specific situations, such as if there are young children involved and you don't want them to receive the money when they turn 18, which is the legal age under Florida law, or if they have special needs and may need some specific ways so that when they get their funds, there would be no loss of benefits, or maybe they just can't manage their money well or have an addiction problem. So those would be some circumstances.
Now, a lot of people have wills, many people don't have wills. What happens if you die without a will?
Well, as I said, that would be an intestate estate, and your money goes according to Florida law. So the real point to take away there is that it is better to take the time to meet with an attorney and draft a will or do your estate plan, so that perhaps you die and you don't have a will, and you have assets in your name alone, and then your brother is the person under Florida intestacy law that will inherit your money, and that wasn't who you wanted to have your money. So those are things to think about. There are a lot of products out there and do-it-yourself products. Unfortunately, that probably leads to a lot of matters that my client handles, because when you do it yourself, you may not be doing it correctly the way Florida law requires to have a will admitted to probate, or you may be drafting it and putting language in there that could change really what your intent is, being a non-attorney who wouldn't be familiar with some of the terms.
Nina, can you share with us, please, what some of the most important estate planning documents are?
Of course, Scott. When I meet with a family or clients to do estate planning, typically we discuss the will or the trust, depending on their specific needs. In addition to that, there's the durable power of attorney. That's probably the most dangerous document, and who you name as your agent is very important, because essentially you are naming somebody who will have the ability to have access to all of your finances and perhaps change beneficiary designations on accounts and do things that you didn't intend to do. The same within the trust. It's imperative that you know who you're naming as your successor trustee, and that person knows that they're being named so that they have an understanding of what their duties and responsibilities are, because even if they don't have ill intentions, they may not really understand the procedures of what happens after you've died in order to administer your trust. And those are the key documents as far as your financial aspects go.
Would you recommend that these documents be prepared by an attorney? Do they have to be?
Under Florida law, they do not have to be prepared by a lawyer. However, I do recommend that in order to make sure your desires and your intentions are carried out the way you want, that they are handled by an attorney.
Well, listen, I learned a lot in your segment about this topic of probate, and I'm very impressed. Tell our audience, if they want to get in touch with you, if they want to retain you, they want to learn more about your firm and probate and all the great things that you do, how do they find you?
Sure, Scott. As I said, I've been doing this over 26 years. I love what I do. I really feel I get to help my clients through very difficult times in their lives when they've lost a loved one or a loved one is dealing with Alzheimer's or dementia or some sort of illness. My firm is Wintter and Associates. My phone number is 954-920-7014, and our website is www.winterlaw, Winter with 2 T's, .com.
Thank you so much for being my guest this evening.
Thank you.
Really appreciate it.
Thank you, Scott. I appreciate the time.
Pleasure.